If you have ever wondered what happens when the contract falls apart because one party doesn't get what they were promised, stick around. Hey everyone, today we're going to talk about a crucial concept in contract law, the law of total failure of consideration. We will break it down, explore how it works, and I'll give you three scenarios to help illustrate this principle. So if you have ever wondered what happens when the contract falls apart because one party doesn't get what they were promised, stick around. Let's start with the basics. Consideration is one of the key elements of a valid contract. Essentially, it's the benefit that each party gets from the contract. For example, if I agree to sell you my car for $10,000, the car is my consideration, and your consideration for the car is the $10,000. But what happens if one party doesn't get any of the promised benefits? That's where the concept of total failure of consideration comes in. It occurs when one party fails to provide what they promised, leaving the other party with nothing. In such cases, the affected party may be entitled to rescind the contract and claim restitution for any payments made. Here's our first scenario. Imagine a small business orders a bulk shipment of electronics from a supplier and makes full payment upfront. The supplier, however, never delivers the goods, nor do they offer any explanation. In this case, the buyer has paid for something they didn't receive, so there's a total failure of consideration. Under the law, the buyer is entitled to ask for his money back. Let's look at another scenario. Say you hire a contractor to renovate your house. You pay them a deposit upfront, but they don't even start the work. Again, this is a total failure of consideration because you paid for a service that was never provided. In this case, you could claim a refund of your deposit. Imagine how frustrating that would be as a homeowner. Thankfully, the law protects you here, allowing you to recover what you paid when the contractor fails to fulfill their part of the agreement. Provided if you have the money to start a lawsuit, and the renovation company isn't bankrupt, or the director did not run away with the money. Now let's talk about an example where performance was impossible from the start. Someone sells you tickets to a concert that's already been cancelled. Since the seller couldn't deliver on their promise and you didn't receive what you paid for, this is also a total failure of consideration. You are entitled to get your money back in this case because the contract was void from the beginning due to impossibility. Now that we've covered a few examples, it is important to highlight that total failure of consideration doesn't apply just because you're unhappy with the quality of the services or the goods. It has to be a complete failure where the benefit you were promised simply didn't materialize at all. So there you have it. The law of total failure of consideration is essential when it comes to contract disputes, ensuring fairness where one party doesn't get the benefit they were promised. Thank you for watching. Don't forget to like, share, and subscribe. I'll see you in the next video.